Good afternoon, everybody. Keith here. Hoping you're all having a good day, enjoying life, living life, loving life. As you can see by the heading on the post, we're talking about driver license in lieu of bail. Imagine that. Remember, if you saw my video last night, we spoke about a number in lieu of the name and address. And that's basically what we're doing. So, if you're paying attention, we're going to go over some things in regards to in lieu of bail. And one of the biggest problems that we have in today's society in regards to bail is these, quote, traffic citations and everything. And they, on the bottom, they tell you an appearance bond of some sort. And that's what we're going to look at in regards to bail and traffic tickets. Being minor ones, whether you're arrested or not, a regular traffic ticket has a bail amount on it. And when we look at various different states, and I've brought this one up before, I've looked at Minnesota, Missouri, Michigan, and you can just tag in, just put in your search engine, depositing driver, or put driver's license in lieu of bail, and then your state. Put state code and then driver's license in lieu of bail in your search engine and see what you come up with. So far, I think there's only 20 states that actually have it on the books. But when it comes to equality of the law among the states, we're talking about all 50 states. Because if one state determines that it has superior standing in equity, in other words, if it's fairer to the people than previous laws or laws of other states, then it can carry over into those other states. The superior fairness of it carries over into the other states. And so we're talking about depositing driver license in lieu of bail in certain cases. Violation of traffic ordinance of incorporated municipality. And the reason I pulled this one up, this is Alabama. This is the first state of the union, and they have this depositing driver's license, but they actually put it violation of traffic ordinance of incorporated municipality. So what does that tell you? It tells you they're running a corporate traffic system, and that if you're not involved in that corporation, depositing the driver's license in lieu of bail is giving up your incorporation, your presumption of incorporation. This is a cancellation or a rescission of the driver's license in lieu of bail. Remember, it's all contracts, people. If you have that driver's license, it's officially recognized as a contract, even though, as I've spoken several times before, I've spoken several times on the fact that the driver's license certification is false. This is the process of a driver's license is a process of a series of transactions to bring about certain facts on the face of the record. Well, one of the first facts that they bring to the face of the record is they say that you're required to register your vehicle. It's not a vehicle. It's an automobile. Like I said, it comes from an automobile manufacturer. And simply because they do an import-export trick with the United States and the states and the dealerships, they're imposing some kind of import duty when it actually hasn't been imported. I mean, if you've got an American automobile industry on the landmass, the only exporting they're doing is when they export it out of the country. How can you export it on the same landmass from an automobile manufacturer through fictional entities? You can't. Those fictional entities only exist on paperwork, and you're not transporting it through the paperwork. You're transporting it over the landmass. Okay? So if you go from an automobile manufacturer that's in Detroit and it goes to Iowa from direct transport on a truck from the plant to Iowa, did it get imported to the United States? Not any sense other than the paperwork. And that's all it is. Period. Plain and simple. You have the same right to do the same kind of paperwork. You don't have to have that officious third-party intermeddler claiming that it's imported when you can prove that it's not imported. It's a custom order. And that's why I spoke in my video yesterday. You don't need to go to these dealerships and pay cash or anything. They're not going to give the MCO. You go directly to the manufacturer and custom order it, so the MCO goes directly to you and not through some importer. And in order to do that, you have to express in your custom order that this isn't for import-export. You have an entrepot right to have it delivered to your door. And use a proxy address to do so. According to what they're saying here, Mike, yes, you can deposit the driver license in lieu of bail. This is Alabama. And I don't have them all up here. But this is Mississippi code, and it says the same thing. This is Title 32, Section 3216 in there. Mississippi has it in Section 63, 925. But it says basically the same thing. Under the laws of any other state or territory or District of Columbia shall be arrested and charged with any offense against the traffic or motor vehicle laws or rules of the road of this state or any municipality thereof shall have the option. That's telling you right there. Remember, I told you yesterday in the last couple of videos, we always have an option. It's a matter of you determining what your option is. And they can't tell you what your options are. They will try to tell you that you don't have the option, that you have to pay bail. But you have to know what your options are. They're not going to tell you your options. So you have to comprehend. You have the option of depositing the driver's license with the arresting officer or the court in lieu of any other security which may be required for his appearance in any court in this state in answer to such charge lodged in such court. So comprehend what that's saying, people. If the officer knows this, which he likely doesn't, when he comes up and asks you for that driver's license, you could technically tell him you are giving him the license at that point in time, the now time, that I hereby transfer this instrument, this driver's license, in lieu of any bail that may be required from here to forthwith. If he doesn't understand that and walks back and tries to give it back to you, gladly accept it. Because he probably isn't going to let you take off without it. But once he gives it back, once you stated that, that's clear evidence in, on, and for the record that you took that option and he took down the information. And if he took down the information in lieu of the instrument, that's on him. You gave it to him in lieu of the bail. He took the information and gave it back to you. He took the information for bail. Okay? You know how to assert that, you can stand on that. That's how that works. Whether he knows it or not, if you inform him prior that you are giving him possession of an instrument in lieu of bail, any bail that may be required from his issuing of any traffic citations, because they will have an appearance bond on there, and that appearance bond is a bail amount. Okay, it is a bail. That's Mississippi. This is Louisiana. Deposit of license in lieu of security. Again, just like this one said, in lieu of any other security. Louisiana also mentions it as a security. Deposit of license in lieu of security upon arrest. Receipt, license to have, or licensee to have license or receipt in immediate possession. Remember what I spoke about yesterday? We talked about customs duties 19, CFR 113.40, and where they talk about satisfaction of lien. Satisfaction of lien is released by giving them by remitting a receipt to them. A receipt is a handwritten statement saying that you release them of their lien. That's an affidavit, superior to any of their certificates, as I've been talking about lately. Their certificates, they cannot authenticate because nobody will sit down and give a handwritten statement with a separate handwritten wet ink signature. They won't do it. That's why you have to give them a receipt. That's part of the problem. We're not giving them a receipt, and they're not taking receipts, and they don't know, again, unless we know this and start acting on this and start giving them receipts and handing over that license in lieu of bail, they won't comprehend this. We have to teach them this. Notification to vehicle owner. Remember, in the motor vehicle operator's lease, it says that part of that agreement is that you are not the owner. So you have to give notification to the vehicle owner. In that notification also of surrendering that license in lieu of bail, you give them notification that certification is false, like I've talked. The motor vehicle operator's lease certification is false because it does not exist, because I made no such certification. I wrote no such affidavit. And then they're going to say, then they say surrender of license, issuance of temporary permits. They're going to, when you surrender that license, they're going to still want to issue you a temporary permit or a suspended license term where you're required to have SR22 or something. No. You already gave the license in lieu of all bails. If they try to issue a temporary permit, that's another bond. That's another bail. It's another bailment. They're trying to sign you right back up. That's why you have to give them a receipt, releasing them of the lien. The lien starts with that automobile lien when they import it to the United States. It's a Customs and Border Protection lien on the property, the vessel. It cannot be on the man. Illinois. Oops, let's try this again. Dang it. There it is. C is what we're looking at, and we're looking at Supreme Court Rule 553, posting bail. Okay? You get that, people? This is an Illinois Supreme Court Rule 553. And we'll take a chance to look that up for the federal code. But right now we're going to go back to Illinois. We're going to read this. By whom and where taken? The several circuit clerks, deputy circuit clerks, and law enforcement officers designated by name or office by the chief judge of the circuit are authorized to let to bail any person arrested for or charged with an offense covered by rules 526, 527, and 528. And these are the traffic laws in Illinois. Upon designation by the chief judge of the circuit, bail may be taken in accordance with this art. It's fancifully written, artistically written, in any county, municipal, or other building housing governmental units, police station, sheriff's office, or jail, district headquarters building of the Illinois State Police, way station, or portable scale unit established for enforcement of truck violations under Rule 526B1 or similar municipal ordinances. Bail deposit by credit card, debit card, or by any other electronic means may only be accepted upon the approval of the chief judge. He wants a financial instrument so he can approve it. He wants to prove that you have the finances and that the person is not innocent. In other words, he wants to make sure that there are funds available by the person. And the circuit clerk's ability to accept such deposits. Individual bonds under paragraph D of this rule may additionally be taken as designated by the chief judge of the circuit. Individual bonds under paragraph D of this rule may additionally be taken as designated by the chief judge of the circuit. Copy of bond receipt for cash bail. Remember I told you, you've got to give them a receipt? You got to get a bond receipt. Get a bond receipt. Or make up a bond receipt showing that you've received their bond and you're giving them a cash receipt. What's that cash receipt? That's that affidavit, people. That's the affidavit. A carbon copy of the bond or an official receipt showing the amount of cash bail posted. The amount, remember we talked about the amount? Their amount is always a par system. You're going to put a whole value, 1.00. And I know a lot of people think I'm crazy about that, but that's all it takes. You are looking to be made whole. There is no dollar amount on it. It is no dollar sign attached to it. It's just 1.00 or 1.00. 1 point whole. Two wholes coming together with a meeting of the minds to create a oneness. Specifying the time and place of court appearance shall be furnished to the accused and shall constitute a receipt for bail. A carbon copy of the bond or official receipt showing the amount of cash bail posted. The traffic citation is what they're talking about here. And it says, specifying the time and place of the court appearance shall be furnished to the accused and shall constitute a receipt for bail. Receipt for bail. You have to give them a receipt in return, saying that you gave them an instrument for that bail. You gave them an instrument for the bail. They copied down information and used it as a receipt for bail. But it's not in affidavit form. Okay. The bond, cash bail, or both shall be delivered to the office of the circuit clerk of the county in which the violation occurred within 48 hours of receipt or within the time set for the accused appearance in court, whichever is earlier. So we see those people that are talking about acceptance within 72 hours, this is what we're talking about. When we accept something within 72 hours by turning around and sending them an affidavit in mail, in private, rebutting the facts that the officer wrote down as a purchase of bail or receipt of bail, we're going to give them receipt in handwritten form, separately signed, as receipt of the information, and release them of their obligation. That's what the release is. The receipt is the written statement releasing them of their obligation. Pure and simple. That's all it is. Settle the accounts, and I release all your obligations. Simple. Then it goes on to say, C, driver's license or bond certificate. So, that little word right there says or. So we can hand over the driver's license, or when he asks for a driver's license, we can give him birth certificate bond with the affidavit, and that's his receipt for bail. In lieu of the driver's license. If he has any questions about that and wants to arrest you alongside the road and doesn't want to accept that birth certificate with the affidavit in lieu of bail, as the law states, then I'll be darned if he wants to take you to that court. He better have his own bond certificate ready to give in exchange. Otherwise, you can take everything that man owns. Everything that man owns with this bond certificate saying so. If an accused deposits a driver's license with the arresting officer, when he pulls you over alongside the road, he's already making an accusation. He turns around and asks you for that driver's license. Have you not already deposited that license with the arresting officer? He has arrested you. He has stopped you. That is an arrest. And if you've deposited, given him that license in lieu of bail, if an accused deposits a driver's license with the arresting officer in lieu of bail or in addition to bail, or deposits a bond certificate, the arresting officer shall note that fact on the accused copy of the ticket and transmit the driver's license or bond to the clerk within the time provided in paragraph B of this rule. Driver's license or bond certificate if an accused deposits a driver's license with the arresting officer in lieu of bail or in addition to bail, or deposits a bond certificate, the arresting officer shall note that fact on the accused copy of the ticket. In other words, there is no place for it on the ticket. He must handwrite it. And transmit the driver's license or bond certificate to the clerk within the time period provided in paragraph B of this rule, and that says 48 hours. Following is a current list of Illinois companies and associations authorized to issue bond certificates to be accepted as bail in minor traffic offenses where the bail does not exceed the amount specified. Remember I told you about these insurance companies and surety bonds? You do not need insurance. If you go to one of these guys and get a surety bond, that is the bond they're talking about here. But in getting a surety bond with any one of these companies, you can present a birth certificate in lieu of the cash. It's uniform throughout all the jurisdictions. So even in the insurance industry, we can turn around and use the concept of using a bond in lieu of cash, in lieu of bail, using a bond in lieu of a bond. Like kind, a promise for a promise. You got to learn how to use this system against them, folks. This is Georgia State, and this is the only place it mentions it, but it does say, relating to display of motor vehicle driver's license in lieu of bail. A bail, this is the amendment, and it says a bill to amend Code Section 17611 of the Official Code of Georgia annotated, relating to display of motor vehicle driver's license in lieu of bail. Recognizance, meaning recognition or incarceration in certain cases, so as to change provisions specifying the cases in which such substitution is permissible, to amend Section 33-34-3 of the Official Code of Georgia annotated, relating to requirements for issuance of motor vehicle liability insurance. So as to provide for certain policy issuance. So you have to have the insurance before they can provide policy issuance. Before you can be provided the policy, you have to purchase it. Makes sense, don't it? So if you don't purchase the insurance policy, does it apply? No. If you offer a bond under the full faith and credit of the United States, is there a limit on the liability paid out? Do they limit it to a $50,000 per person hospital pay? Can't. The state is subject to the same full faith and credit as the United States. Bond for bond. Here, I'll give you the license as the bail. It's a bond. It's telling you, they're telling you that license is a bond. When we look up Rule 553, this section applies according to the provisions thereof, except to the extent that there is involved a military or foreign affairs function of the United States. Remember, we have a commander-in-chief. He is called a president, and everybody believes that he's president of a country when he's actually a president of a corporation, and that he is known as commander-in-chief of the military of that corporation, the enforcement of that corporation. The military branch of that corporation has a Duns and Bradstreet number. A matter relating to agency management. All of the rulemaking anywhere, whether it be United States or any state of the Union, is in regards to a matter relating to agency management. Pure and simple. That's all it pertains to. Or personal or to public property. Not of public property, but to public property. Loans, grants, benefits, or contracts. What state are you in? Tell me a state, we'll look it up. By the way, good afternoon again, everybody. just to let everybody know. Hope you're having a good day, enjoying life, living life, loving life. That's something I say at the beginning of all my videos. But a lot of people don't get to hear it if they come in after the beginning. So, there you go. Along with that, you guys know you have to know that I don't do this except for you, because I don't need a license. Believe you me, I'll go out and travel around in somebody's car if they'll let me. And most anybody that knows me lets me travel around in their car, no problem. They know I am capable of that objective determination. When it comes to driving, I don't drive. I don't need a license. I don't need insurance. I already know there's in place in their system a way of taking care of it, and I can hand something over like a handwritten statement separately signed in lieu of. And I can do that all by myself. I don't need their bonds. My word is my bond. And as long as I know the correct way to construct it, there's no need for any of their paperwork. I can create it all myself. And that's what you get, and that's the point you guys need to get to. You need to start learning how to construct your own rebuttals to these people. When he pulls you over alongside the road, have a birth certificate already authenticated with the affidavit attached to it, ready to hand him in lieu of the driver's license. If he doesn't want to accept that, that's on him. That's his onus. You know, you're abiding by their own construct of the laws. And like I said, if you're in a state that doesn't acknowledge that on and for their record, this is the importance of equality of the law among the states, and you use another state. And you can bring in, like I said, several states. Like I said, I think I've run across 20 states so far that have this specifically in their code, in lieu of driver's license, in lieu of bail, specifically. And if that many states recognize it, then all states recognize it. Some way or shape or form. They just don't acknowledge it on the record. Anybody got a state that they want me to look up? We can do that, certainly. Delaware. Mary says Delaware, Texas, New York, Pennsylvania. Okay, let's go, folks. We're going to get rid of. And what was that? That first one was what? Delaware. Mary, here we go. Delaware is Title 21. When we go to 21, and this is how you do this, folks. When you have pages and pages and pages and pages, and you don't want to go through there and scan, and you go up here in the top right-hand corner, go down here to find. It's going to give you, and it says 0. So they don't speak of license in lieu of bail here. But it is imposed, again, by admission of equality of the law among the states. The next one was Texas, and I do believe they have one. This one's such a wide page. Let me bring it down. Do it this way. Okay, there we go. Definition of bail bond. A bail bond is a written undertaking. You get it, folks? All of their bonds are certificates. You get it? That's why they're in certificate form. They look like a certificate. And they're all certificate bonds, certificated bonds without a written undertaking. They cannot be authenticated, like I said. They cannot be authenticated. A bail bond is a written undertaking entered into by the defendant and the defendant's sureties. That tells you the defendant is not the surety. The defendant and the defendant's sureties. Okay? Remember what I was telling you yesterday. The person is not the surety. The surety is the number. It's the import number. For the appearance of the principal. Telling you again, the defendant is not the principal or the surety. So if the surety, if the principal is the one that's supposed to be benefiting, the defendant is acting as trustee, and their surety number is the beneficiary. That's all screwed up according to their bail bond system. That's what we're correcting. We are placing ourselves as the beneficiary of the principal, with their surety as being the trustee, and we should be able to come in as the defendant being the grantee or executor, telling them how to pay the surety. Okay? For the appearance of the principal therein before a court or magistrate to answer a criminal accusation, provided, however, that the defendant on execution, what did I just say? The defendant executes. That the defendant on execution of the bail bond, what did I just say? The defendant executes the surety, may deposit with the custodian of funds of the court, not the judge, the clerk, in which the prosecution is pending, current money of the United States in the amount of the bond in lieu of, having surety signing the same. Again, on execution of the bail bond, that license is a bond. You can hand that bond over to the court. It's not saying specifically here that you can hand the license, but it is a bond, and attached with a written state undertaking, you can hand it in lieu of, as the defendant executing the obligation of the sureties. Okay? Does that make sense, Mary? I hope so. Cornelius, that's the Texas one. Mary, it works the same way in Delaware. Joe, it works the same way in Pennsylvania and New York. Everywhere. So let's look up New York, see what New York's got. This is not New York, this is Alabama. Okay, there's Louisiana, but you still see it says deposit of license in lieu of security upon arrest, receipt. So, deposit of license in lieu of security upon arrest or receipt. So when he gives you when he pulls you over alongside the road, he's already arrested you. You can deposit the license in lieu of security upon that arrest, or even when he gives you the ticket, you can write yourself on the ticket. You can give a written undertaking on the ticket. License given in lieu of bail. And they have to accept it. If they don't, and they further arrest you and take you before the court, then somebody sooner or later is going to understand, is going to have to comprehend the security and their liability and obligation to it. Because if you keep asserting that you're the, like I said in that other one, as a defendant, operating as a defendant, don't admit that you're the defendant, but that you're executing in the principal capacity to have the sureties taken care of. The surety is their security. It is their obligation. Again, 18 of the U.S. Code, Section 8. Obligation or the security of the United States. Let's see, what's the next one? That was New York, Pennsylvania. That's Illinois. And just to show you, makes a stylistic change. Amend the Illinois Vehicle Code. Makes a stylistic change in provisions concerning the depositing of a driver's license in lieu of bail. When a license is deposited as security. As security. As security. That's telling you that that driver's license is a security instrument, folks. This is why God bless the heart of the people that want to help but don't deal with PayPal, and so I have to get contributions every once in a while through Walmart, and I have to go into Walmart with this funny ID, and they want me to specifically hand them that security instrument, and I tell them I can't do that. If I hand them that security instrument and they take possession of it, they now have to accept full financial liability. Because if they put it in that machine, in that electronic reader, somehow screws up my card and I can no longer use it in the next electronic reader, then they're liable. Same thing with the officer alongside the road. When you hand him that license, he's now liable. He is the obligated party. He's the one that holds the instrument. And he's the one that's demanding it, saying he has authority to be the holder. Over you, the one that applied for it. Is that stupid or what? Uh-huh. So we really need to think about this stuff, people. Really, really need to think about this stuff. We were on Pennsylvania. Let's see if we can find Pennsylvania. Well, this isn't a particular state, but this happens to be an interesting article here already. It says, another method to vacate a conviction following a failure to appear and entry of a driver license forfeiture. We're going to post that in the comments here for you, folks. There's a nice article. I want everybody to read. I'm going to read it myself when I'm done here. Of course, it's coming from a law office. Always remember that. It says right there, this is a legal article, was published in a leading law publication called The Docket. So these guys do know what they're talking about in regards to moving around these courts. But again, remember, they are attorneys. Do not hire them. We can use their codes, rules, and regulations. And here it tells you the operative statute is 735 ILCS 52-1.401, Code of Civil Procedures. And as we saw earlier, folks, it not only mentioned civil procedure, but it was talking about criminal procedure, which is what I'm telling you, is their criminal procedures are actually only involved after they act civilly. They have to have a contract in order to make an accusation that then they then turn around, call or define criminal, when in fact it is not actually criminal. It says relief from judgments. Relief from final orders and judgments. And remember, people, this is something I've been doing from day one. I've been taking other undertakings, as well as written undertakings here on Facebook. And these people watch my page. That is a written undertaking that I have also, you've seen many of my documents, as well as I've done some handwriting documentation. I know what all of this stuff says, and I know how to rebut it, and so I've done so by my actions. These people watch my page to this day, just like you guys watch my page here. The people that arrested me watch my page. They are trying to learn, just like we are. The problem is they're trying to learn how to keep people like myself from educating people like you. While at the same time, they're comprehending how much I'm learning and showing how they are mistaken in their ability to even come against me. Little old me, my oneness. And it's all by knowledge, people. All by knowledge. Relief from final orders and judgments after 30 days from the entry thereof may be had upon petition as provided in this section. And again, if they provide under a privilege that you may petition, then I assert by right we have a superior right not to petition, but to make a formal demand. A profess a command. Not a demand, a command, as provided biblically through ancient documents. Writs of error, coram nobis and coram vobis. Bills of review and bills in the nature of bills of review are abolished. Get it? They don't have any bills of review. They're abolished. They don't have any bills saying they have to go back and review a judgment that's already been made. They can't provide relief. Only you can. Again, writs of error, coram nobis and coram vobis, bills of review, and bills in the nature of bills of review are abolished. They can't do it. Their certifications are false. They can't give a written undertaking, reviewing. All relief heretofore obtainable, and the grounds for such relief hereto available, whether by any of the foregoing remedies or otherwise, shall be available in every case by proceedings hereunder, regardless of the nature of the order or judgment from which relief is sought, or of the proceedings in which it was entered. Pure and simple. Yeah, see, they're not saying in lieu of on this one, but it tells you that you can do the same thing as the other states. You can give a written undertaking. My word is my bond. Okay? I went over this in regards to I'm going to call you Cornelius because it just doesn't sound right. Cornelius, Odell Hicks. But the DBA comprehend people doing business as when you register the business. You just pledged. If you're going to start your own business in private and then turn around and pledge it, what you've done is just created an entity and then gave it up. Why? This is the same thing that inventors do when they get patents on their inventions. They come up with a concept and then they pledge it. They give it up by filing a patent in the public. If you want your invention, if you want your business to remain private, you cannot put it as a registered public information. You have to keep that private. That way, anybody that wants to come to you and ask you what you qualify in your conduct of business, they have to come to you. They don't go to state statutes and then say, well, you have to follow the state statutes because you register your business. That's where these statutes and everything get all their authority, is everybody's registering their kids, registering their property, registering their businesses, registering their ideas. Quit it. Quit volunteering. Quit volunteering, please. You can do things in lieu of. There's an option. Learn your options. Quit believing that they tell you you have to do it this way. You have options at all times. If we didn't have options, then life would be stagnant. It would be still. It would literally be death, a nothingness. This is what life is about, is having those options. I hope I've instilled in you guys to look this stuff up and really learn and know for yourself. There is never anything that can hold you back unless it's yourself relinquishing to the one option that somebody else gives you. You are creators. You create your relief. You create your remedy. You create your cure. Because they won't. They're only going to tell you they have one option for you. And if you don't do it, they're going to do something to you. Really? Really? Last time they made that threat on me, I was walking out of jail and they told me if I didn't sign, they couldn't let me out. I was out less than 5 minutes, quicker than I've ever been out of there in my entire 54 years. And my rap sheet's this thick, folks. And all I did was tell them I ain't gonna sign. And they insisted that I had to. So I pulled out the paper in my pocket and said, so you're going to violate the judge's discharge order? Huh? And like I said, I was out of it quicker than I've ever been out. Learn your options. They give you options if you look for them. And they tell you don't have options in many cases, thinking that you won't look for them. But you need to. Because they are lying to you. Like I said, ask anybody to take a separate written undertaking along with that certificate. They ain't gonna do it. They won't sit down and put pen to paper and write in their own words that that certificate is in fact a bond, and it bonds you, him, and the paper. Really? I don't know anybody that's going to step up and take that. My mom and dad won't even do that. So think about this stuff, people. I'm going to get my other forum links tapped into this video when I get done here. Please hit that share button on the PayPal link. I could always certainly use it. In the meantime, remember to share the information, share the videos, and share the forum links. Get it out there. Share, share, share. I'm doing my duty by doing my own research and educating myself and passing this information on by sharing it. Please do your due diligence and duty of sharing that as well. But again, please hit that PayPal button. I love you as well. Remember, folks, if it weren't for you guys, I would not be doing this. I wouldn't be doing these videos showing you this stuff. I already know it in my heart. It's there. All I got to do is, if I ever have any questions and somebody tells me I only have one option, I'm going to say, well, I asked for leave of court or whatever it's going to take to go do some research, come back with a different option. So think about it. I love you guys. Have a great day. Be blessed. Bye.